during the course of which the court had submissions from 9 counsel for the applicant, 32 for various respondents, and from 3 counsel representing the friends of the court. They represented 69 applicants, 30 respondents, and 2 NGOs admitted as amici curiae. From onset, this court wishes to thank all the parties, including the amici, for their assistance in this matter. We have prepared a written judgment dealing with issues before us, reasons for the conclusions we reach and the orders that we make. The full written judgment will be available electronically for the parties, media, and interested parties as soon as it has been handed down. In other words, when this court rises. In order to obtain copies, all what interested parties need to do is to supply their email to the registrar here in court, who will then email the judgment. The full judgment speaks for itself. For the benefit of interested parties and members of the public present in court, I will give only an outline of the judgment. The outline is not a substitute for the full judgment, which must be read in its entirety to be understood. Gold mining began. The industry left in its trail tens of thousands, if not hundreds of thousands, of current and former underground mine workers who suffered from debilitating and incurable silicosis and pulmonary tuberculosis. Many mine workers also died from the diseases. Soon after the commencement of gold mining, the risk of underground mine workers being adversely affected by the exposure to silica dust and thus suffering from silicosis became manifest. There are other occupational lung diseases in the industry, but silicosis and to a lesser extent TB are the two that are of concern in this case. From as early as 1902, several commissions of inquiry were appointed by the government to investigate the causes and prevalence of silicosis. These commissions found the inhalation of excessive dust to be the sole cause of silicosis. The commissions recommended that dust control and dust elimination measures be introduced. There were other studies and investigations, including some by the mining industry itself, which made similar findings. These developments sketch and lay down a wide carpet of information that became available and accessible to those involved in the gold mining industry. This case is about the attempts by the mine workers employed in the gold mining industry and their dependents to obtain compensation as a result of mine workers having contracted silicosis or TB. The applicants seek to bring a class action on behalf of current and past underground mine workers who contracted silicosis or TB, and on behalf of the dependents of mine workers who died of silicosis or TB contracted while employed in the gold mines. The applicants seek an order for certification of one consolidated class action comprising 2 classes, namely a silicosis class and a TB class, against companies operating in the gold mining industry. It is their proposal that the single class action proceed in two stages, one during which issues common to both classes shall be determined, and stage two, during which individual issues are to be determined. They refer to this as bifurcated process. Save for the 29th respondent, Rand Gold and Exploration Company Ltd., the application is strenuously opposed by all the gold mining companies which are cited as respondents. Rand Gold abides the decision of this court. It is common cause that the potential class members may range in numbers from 17,000 to approximately 500,000. The bulk of them belong to Silicosis class. The mining companies, who are all potential defendants, represent almost the entire gold mining industry in South Africa. The scope and magnitude of the proposed silicosis and TB claims is unprecedented in South Africa. The action, if it proceeds, will entail and traverse novel and complex issues of fact and law. The law on class action in South Africa has developed against the backdrop of a provision in the Constitution which provides for a person acting as a member or in the interest of a group or class of persons to approach a court for relief. The South African Law Reform Commission played a part in pointing a direction for development. The current law is neatly summarized in two decisions, one of the Supreme Court of Appeal in a case commonly referred to as the Children's Trust case, and the other of the Constitutional Court in a decision commonly referred to as the Macadam case. The details and principles that govern class action are set out in our written judgment, to which we refer without repeating here. To sum up, a class action represents a paradigmic shift in the South African legal process. It is a process that permits one or more plaintiffs to file and prosecute a lawsuit on behalf of a large or larger group or class against one or more defendants. The process is utilized to ally parties and the court to manage a litigation that would be unmanageable or uneconomic if each plaintiff was to bring his or her claim individually. It is normally instituted by a representative on behalf of the relevant class of plaintiffs. The class action process is part of the equity developed law and is designed to cover situations where the parties, particularly plaintiffs, are so numerous that it be almost impossible to bring them before the court in one hearing, and where it would not be in the interest of justice for them to come before a court individually. It is not only for the benefit of the plaintiffs that class action process was conceived. It is also designed to protect a defendant or defendants from facing a multiplicity of actions, resulting in it having to recast or regurgitate its case against each and every individual plaintiff. Furthermore, it enhances judicial economy by protecting courts from having to consider the same issues and evidence in multiple proceedings, which carries with it the possibility of decisions by different courts on the same issue. On the other hand, a class action allows for a single finding on the issue or issues, which finding binds all the plaintiffs and all the defendants. Since the pronouncements of the Supreme Court of Appeals in the Children's Trust, a class action can only proceed to trial if it has been certified by the court as being an appropriate means of resolving the dispute between the parties, the putative class members, and the defendants. Supreme Court of Appeals did not, however, restrict this prerequisite to cases where no right in the Bill of Rights has been evoked. South African Law Commission recommended that a settlement reached after the class action is certified should be approved by the court for it to be valid. Neither the Supreme Court of Appeals in the Children's Trust nor the Constitutional Court in Mukadam addressed this issue. In the present case, as appears later in this judgment, such approval is obligatory, as the provisions of the Contingency Fees Act 66 of 1997 are applicable. We hold that, in any event, it is correct that any settlement agreement reached after certification of class action should be subject to the approval of the court, and that it should only be valid once approved by the court. This is to ensure that the settlement reached is fair, reasonable, and that it protects the interests of the class. After examining the relevant legal prescripts against the facts of this case, we reach conclusion that there are sufficient common issues in the proposed claims to justify the class action in which there will be two subclasses, the Silicosis class and the TB class. We conclude further that the common issues in the class action may not finally determine each minor's case. There will therefore be two stages: Stage 1 to determine common issues, and Stage 2 to determine individual issues. The fact that the determination of common issues in favor of the mine workers will not finalize each minor's case, or that of his dependents, is no bar to the class action. A certification is not dependent on each minor's case being fully and finally determined once the common issues are determined in favor of the mine workers. As long as it can be shown that the determination of the common issues will advance the cases of the individual mine workers substantially, a certification of the intended class action would be justified and would be in the interest of justice. At the same time, it cannot be overlooked that the cases of all mine workers could very well be finalized if the trial court were to find against the mine workers on one or more of the common issues. This could happen, for example, if an issue such as prescription is determined in favor of the mining companies. In this scenario, the entire cases of all the mine workers, or of a substantial number of them, could be finalized. This possibility on its own bears significant weight in favor of certifying the class action. All the mining companies are accused of having committed the same wrongs, failing in their duties to protect the health of their employees, the mine workers, when they were legally bound to do so, and as a result thereof, causing them to suffer the same harm, contracting the disease of silicosis or TB. However, sight must not be lost of the fact that this case is different from the usual class action where numerous persons have the same or similar claim against a single defendant arising from a single wrong committed by the defendant. In this case, numerous mine workers have the same claim against one or more of the mining companies simultaneously, and while all their claims are attributable to a single cause, the harm nevertheless occurred at different times and in different circumstances. The mining companies placed heavy emphasis on this latter fact in their opposition to certification of the class action. What the mining companies do not gainsay is that all the mine workers have a similar, albeit not same case. They've all worked in the mines owned, controlled, or advised by one or more of the mining companies. They've all contracted silicosis or TB. That the exposure to silica dust was the sole cause of them contracting silicosis and a major contributing factor to them contracting TB. In other words, all the silicosis mine workers have a claim harm suffered at the hands of one or more of the mining companies attributable to a single cause, even though the harm they are alleged to have suffered may have occurred at different times, in different circumstances, and in different mines. At the same time, all the TP suffering mine workers claim that a major, if not sole, cause of their contraction of TB lies in their exposure to silica dust, which was prevalent at the mines they worked in. The mine workers correctly point out that should the class action not be certified, the evidence they refer to and which we have summed up in this judgment would have to be repeated in each individual case that may be brought, resulting in it being presented many times over. And it would be presented by the same witnesses in each of the cases. On the contrary, if the class action were to be certified, it would be presented only once. Hence, the constellation of evidence can only be presented in a class action trial. It is neither economic nor, in the case of any individual mine worker, affordable for him to bring it to his trial action were he to sue in his individual capacity. In a class action trial, the mining companies will be able to challenge all the evidence once, and to the extent that they will bring direct contra evidence, this too can be done once. The class action trial court will deal with all the evidence once and for all, and will make a single finding on the issues arising from the evidence, as opposed to many trial courts sitting and hearing the same evidence. It has to be borne in mind that if individual trials were ever to be held and evidence presented in each of the cases, the findings on each case remain case-specific and are not binding on any subsequent case, even though the subsequent case draws on much of the same evidence as the previous one. It goes without saying that there is always the problem of different courts hearing the same evidence but coming to different conclusions. And even making mutually contradictory findings. This is untenable and it is uneconomic. Thus, if jurisprudential coherence and integrity are to be maintained, which in the interest of the rule of law there must be, then evidence can only be presented in a class action hearing. In other words, the evidence is only truly digestible in a class action hearing. Thus, in our case, the class action would not only be to the benefit of the mine workers, but also to that of the mining companies, which raise defenses that are common to all or most of the mine workers. At the same time, the court would be saved the inconvenience of dealing with more than one case and hearing the same evidence over and over. Thus, it would enhance judicial economy. Further, it would prevent the potential harm to judicial integrity caused by various courts hearing the same evidence and producing conflicting decisions from that evidence. The mine workers have urged the court to consider that in the context of this case, there is, for most victims of silicosis and TB, no realistic alternative to class action. For them, it is said, it is class action or no action at all. Class action is the only realistic option open to the mine workers and their dependents. It is the only way they would be able to realize their constitutional right of access to court, bearing in mind that they are poor, lack the sophistication necessary to litigate individually, and have no access to legal representatives, and are continually battling the effects of extremely debilitating diseases. This is manifest in the following uncontested evidence of Spoor. Quote, "It is not disputed that the majority of the class members are impoverished rural people, many of whom are in poor health, who are spread across the subcontinent and who have limited access to the civil justice system. The very large proportion of class members who are migrant workers from Mozambique, Malawi, Lesotho, and Swaziland probably have no access to the South African justice system at all. Litigating on behalf of claimants located in remote rural areas and in neighboring countries, it's particularly difficult and expensive. Communication is difficult and expensive. In many instances, letters and notices must be delivered by hand. Travel to and from these remote areas is slow, expensive, and unreliable. There are few, if any, local correspondent attorneys to rely upon, and either the attorney must travel to see the client or vice versa. A simple matter such as arranging a medical examination can take days to organize and involve claimants traveling hundreds of kilometers. All of these costs must be borne by the client, which is impossible, or they must be borne by the attorney." Close quote. While the factual metrics of the position of most mine workers is not seriously disputed by any of the mining companies, they simply deny that class action is the only viable option. They do so without advancing an alternative option that will guarantee access to justice for the mine workers. The mining companies argue, in the main, that class action of the magnitude sought by the mine workers will be unmanageable. The mine workers accuse the mining companies of not acting in good faith. They also accuse them of doing all to escape justice. The mining companies fail to dispute the claim or present credible evidence to doubt it. They know, claim the mine workers, that if class action is not authorized, that most of the mine workers and their families will not be able to access justice. It was not disputed that the majority of the mine workers have little to no access to South African justice system, as they are impoverished or indigent and are living in rural areas of South Africa, Mozambique, Malawi, Lesotho, and Swaziland, and are in poor health. They form part of what in one judgment was described as, quote, the millions of people that are living in deplorable conditions and in great poverty, close quote, in this country and the neighboring states. We have to assume, for the present purposes, that the mining companies violated their constitutional, statutory, and common law rights, as at this stage, the mine workers have made out a prima facie case in this regard. That being so, the vast majority of them who cannot sue individually would have to live with the fact that the law, with all its promises, affords them no remedy for the pain and suffering endured while battling the growth of the fibrotic forest in their ever-depleting lungs. If the legal system is inaccessible to them, then the constitutional gift of a right of access to court is illusory. It is only through access to courts and other independent tribunals that justiciable disputes can lawfully be adjudicated. This makes the right of access to courts one of the cardinal importance in our constitutional democracy. If access to court is denied to them because the court refuses to allow them to follow a particular process, such as class action, when no other is available, then the rule of law, in our view, is ruptured. Access to court is an ingredient in the making of the rule of law. We hold the view that in the context of this case, class action is the only realistic option through which most mine workers can assert their claims effectively against the mining companies. This is the only avenue to realize the right of access to courts, which is guaranteed by the Constitution. After examining the relevant considerations and submissions, we reach conclusion also that the class representatives, their legal representatives, and the final fee arrangements put before us are suitable, and we confirm accordingly. There is no real sustainable objections to their suitability based on relevant legal considerations. The mine workers ask that the court sanction the notices annexed to this judgment as B1 and B2. The mining companies oppose this. They claim that the notices are too complicated and inappropriate, given that the large majority of the mine workers are either illiterate or semi-literate. They, however, do not suggest any alternative wording of the notices. It is really difficult to see how the notices can be simplified. They are brief. They say what needs to be said and no more. They are neutral and objective. They avoid any ambiguity, and they will be translated where necessary. They must be seen in the context of the existence of an active network of trade union community-based organizations and associations of former and current mine workers that were referred to in this judgment. The message in the notices will, in all probability, be carried with ease to the mine workers should the process referred to in the order we make below be followed. If for any reason the process cannot be adhered to, or if the mine workers and the mining companies jointly deem it necessary to augment the notices through an additional process, then they are free to do so by agreement amongst themselves. If, on the other hand, they are unable to do so, then any party is free to call upon this court for further direction or even for the amendment of the notices of order. In our view, the notices as they stand are sufficient, and so too are the processes that will be set in motion to advertise them. They are designed to ensure that they are brought to the attention of the maximum number of mine workers possible. Simultaneous with its answering papers, Harmony launched a conditional counter-application. The counter-application is conditional upon this court certifying the class action. In that counter-application, Harmony seeks an order directing the mine workers, 1, to deliver a report confirmed under oath by their attorneys listing and each envisaged plaintiff in the Silicosis and TP class action who may have instructed legal representative to institute proceedings on his or her behalf. 2, furnish copies of any fee agreements, powers of attorney, letters of instructions, and or other mandate documents which may have been signed or authorized by a mine worker. 3, include in their periodic reports envisaged in the then prayer 9 of the amended notice of motion a list of all persons who have given or may give notice of a wish to be excluded from the membership of any certified class at the stage of the class action or be included as members of any certified class at the second stage of the action, together with copies of such notices. After considering same as well as submissions made for and against the counter-application, we concluded as follows. The counter-application effectively seeks to anticipate the opt-in stage, or is a pre-discovery fishing expedition. There is neither a right nor a legitimate interest that Harmony seeks to enforce or protect that would justify the granting of the orders it seeks. Accordingly, Harmony is not entitled to the relief it seeks, and in the result, the counter-application stands to be dismissed with cause. The mine workers have also asked this court to declare that any claim for general damages that a mine worker brings or may wish to bring against any of the mining companies is transmissible to his estate should he die before the litigation reaches the stage known in the common law as litis contestatio. In order to make sense of this relief, we found it necessary to explore the historical roots and development of our law of delict regarding the transmissibility of claims for damages, whether general or specific, to the heirs or estates of the deceased. To begin with, it is necessary to have regard to the historical development of the concept of litis contestatio, commencing with the early Roman law. In the judgment, we examine the origin of the current common law principle on transmissibility of damages and how it developed from Roman law through Roman Dutch law up to and including modern-day South African law. We make a comparison with the developments in other jurisdictions, significantly with developments in the United Kingdom, Australia, and the United States of America, where there were legislative interventions. We conclude that these legislative interventions demonstrate that the law, which prohibits the transmissibility of general damages pre-litis contestatio, fails to reflect the boni mores of a modern society organized along the principle of the rule of law. We acknowledge the constitutional imperative on this and other courts to develop the common law. In South Africa, this responsibility to reform and refocus common law in order to keep it abreast of current and social conditions and expectations is entrusted in the Constitution, with the added obligation that judges do so in a manner that is consistent with and gives expression to the rights articulated in the Bill of Rights. Subsections 8.3 and 39.2 of the Constitution explicitly enjoins the court to develop the common law to the extent that it is necessary to make it consistent with the values enshrined in the Constitution, especially those explicitly mentioned in the Bill of Rights. Thus, it is the constitutionally imposed duty of this court to develop the common law in order to harmonize it with the Bill of Rights. The development must reflect the spirit, purport, and objects of the Bill of Rights. We are duty-bound to develop the common law so that it does not deviate from the spirit and objects of the Bill of Rights. It is a duty we cannot and do not abdicate. The mine workers claim that the existing common law in South Africa violates their rights to equality, human dignity, life, freedom, and security of the person and access to courts. They say that the failing of the common law is a constitutional matter that requires redress by this court. By refusing to transmit their claim for general damages to their estates upon their deaths, the common law violates their right to bodily integrity. Their right to bodily integrity is an integral part of their freedom and security of persons. The right to bodily integrity is vindicated by them being compensated in the form of general damages by the wrongdoer, in this case, the mining companies. The benefit they acquire from this is, without doubt, shared by their dependents. Denying them the opportunity to transmit this compensation of general damages to their estates effectively removes their right to bodily integrity. To the extent that it does so, the common law is incompatible with or deviates from the Constitution. They are entitled to the compensation from the wrongdoer, and their dependents are entitled to benefit therefrom. The fact that the harm to their bodily integrity was specific to them is not and should not be a bar to their right to compensation post-mortem. That they themselves would not have received the benefit during their lifetime is of no moment. As the common law presently stands, it unjustifiably takes away from them the right to see that the beneficiaries of their estate, who in most cases are their dependents, receive the benefit of compensation that they are entitled to and would have received, but for their premature deaths, which premature death was caused by the acts or unlawful omissions of the mining companies. For this reason, the common law has to be developed so that they are allowed to transit their claims to their estates upon their deaths. The argument bears considerable force. We examine the question whether the development of the common law should be left to be dealt with by the trial court in due course. The mine workers contend that this court should determine the issue now. One of the mining companies, African Rainbow Minerals, maintains that the issue should be left to the trial court, as that court will receive more evidence and therefore will be able to make a more informed decision on the matter than this court. We disagree with African Rainbow Minerals. All the facts that are pertinent to the determination of this issue are already known and placed before this court. The key facts are these. 1, the stage when litis contestatio will be reached, in this case, if indeed it will be reached, is very long way off. 2, the mining companies agree that a large number of the mine workers have already lost their lives as a result of contracting silicosis or TB, and that the only new evidence that the trial court will receive on this issue is that many more would have died before the state to the undue, unjustified, and irreparable prejudice that will ensue if the issue is left undeveloped. 3, the common law in its present form endorses the financial loss and social harm that the estates of the deceased mine workers and their families endure as a result of these mine workers succumbing to the diseases of silicosis or pulmonary TB. The mining companies are the only ones which benefit from this state of affairs, and their benefit is at the expense of the deceased mine workers and their dependents. 4, it is common cause that the law does not reflect the legal convictions of the community and violates a number of constitutional principles, some of which we have referred to, and to that extent, it fails to promote the spirit, purport, and objects of the Bill of Rights. And 5, finally, the issue has been extensively canvassed in the pleadings before this court and comprehensively argued by the parties. There is no doubt that the facts of this case, on the face of this, a huge injustice would result if the general damages that would have been due to the now deceased class member is denied simply because he succumbed to his disease before the case he brings or intended to bring had reached the stage of litis contestatio. The injustice is all the more poignant when regard is taken of the fact that a denial of the benefits of general damages to the beneficiaries of the estate of the deceased class member could well result in the mining companies securing a benefit from the very harm they caused the deceased class member. Undoubtedly, the loss of general damages by dint of operation of the existing common law will in this case be borne by the widows and the children of the deceased class member, as they would have benefited should their primary provider not have died pre-litis contestatio. It bears reminding that they are the indigent, the weak, and the vulnerable in our society. That they should bear this loss and the respective mining companies benefit from the death of their spouse and or parent is grossly unjust. especially when regard is taken of two facts. One, the respective mining company's conduct or wrongful omission may be a significant contributor to the early death of their breadwinner. And two, the respective mining company's attitude and approach to the litigation has a significant influence over when the stage of litis contestantio is reached. In fact, to the extent that they can amend their pleadings at any time before judgment is given by the trial court, they have significant, if not determinative, control over when the stage of litis contestantio is reached. Consequently, if the law is not developed, then in this case, it would have failed the weak individuals and benefited the powerful corporates. It has to be borne in mind that while the mine worker experienced pain and suffering from the loss of amenities of life prior to his death, his widow and children too bore some hardship by virtue of the care they were required to give to him as a result of his loss of amenities of life. In the light of these circumstances, and bearing in mind the injunctions of subsections 8.3 and 39.2 of the Constitution, it is our view that the common law has to be developed to allow the claim for the general damages to be transmissible to the estate or executor of a deceased mine worker, even though the stage of litis contestantio had not been reached at the time of his death. Also, the development is necessary in the light of the court's general duty to do justice by the person affected by its orders. By holding that the common law can only be developed in the manner we suggest below does not, in our view, mean that we have ignored the judicial caution captured in the dictum that judges should only develop the common law incrementally. Judicial caution in this regard, it has to be remembered, is born out of a need to ensure that the judicial arm of the state does not trespass on the field reserved for the legislature. Legislature is doubtlessly better placed to make laws than the judiciary. But as we point out above, judges are often required to make law for no reason other than to ensure that the law adapts to the new circumstances and meets new challenges. This, we believe, is all we are doing. Moreover, the need for judicial restraint expressed in the dictum does not mean that we must always only develop the law piecemeal. How the law is developed depends on the circumstances that prevail at the time. Of course, if it is possible to make a small adjustment to the law in order to make it reflect the spirit, purport, and objects of the Constitution, then this must be the route to follow. But if by doing so we create as many problems as we attempt to solve, or to put it differently, we create as much hardship and injustice as there already prevails in law, then small or piecemeal adjustment is to be avoided. The approach we advocate is not an innovation of ours. It has long been part of our law. More than a century ago, Ines J. said, quote, "And we should be slow to perpetuate a form of legal remedy which may work hardship if it can be modified so as to do away with the possibility," close quote. We hold the view that this is precisely what will occur if we are to develop the common law on transmissibility of general damages only for class action suits. We have no doubt that the problems we allude to in this judgment and in previous paragraphs are bound to surface in practice. The only way justice can prevail in the cases of the individual mine workers or their dependents is if they are afforded an opportunity to pursue their claims by at least having significant parts of it determined through class action. Further, in our judgment, it is in the interest of the mining companies that the many common issues as well as the common evidence referred to above be dealt with in at-large proceedings. As for the practical arrangements, we hold that these can be fully and finally determined by the trial court after pleadings have closed and all the factual and legal issues have been crystallized or been identified. It is not within the power of this court to prescribe to the trial court how it should structure its hearings. Accordingly, we reject the submissions of mining companies that class action is untenable and unmanageable, and hold to the contrary. We wish to reiterate that by holding that it is in the interest of that justice that class action be certified in this case, we do not, as was contended by the mining companies, hold that the mining companies are jointly liable for the harm suffered by an individual mine worker. Our law of delict is clear in this regard. A defendant can only be liable for his own delict and not for that of another defendant. The liability of each mining company will be determined at the second stage of the proceedings when all the mine workers and all the dependents of the deceased mine workers have staked their claims. At that stage, the claims will be paired against the respective mining companies alleged to have committed the delict. Hence, each mining company will be held liable or responsible for its own actions or unlawful omissions. But this does not affect the fact that a substantial body of evidence to be led against them is the same or common to all of them, and that the evidence is relevant to the individual mine worker's case. Once this is received, the common factual and legal issues are determined. The case, if necessary, will proceed to the next stage where the individual culpabilities will be scrutinized and determined. On the question of costs, the mine workers seek costs against the mining company, including costs of 9 counsel. They have assured the court that the services by counsel were shared and there was no duplication. The costs will follow that pattern. They assured the court that the combined costs of 9 counsel shall not exceed the cost of 3 counsel. This we find is justified, having regard to the complexity of the case and the aggregated strength of opposition by the mining companies. Counsel for the mining companies, like those for the mine workers, shared responsibility and topics in presenting the case to this court and would, if successful, all have been included in the mining company's entitlement to costs. The cost orders sought by the mine workers is, in our judgment, justified. For the aforesaid reasons, and for reasons more fully stated in the written judgment which we shall hand down, the court makes the following order. 1. It is declared that the following persons constitute a class. 1.1. Current and former underground mine workers who have contracted silicosis and the dependents of underground mine workers who died of silicosis, whether or not accompanied by any other disease. 1.1.1. Where such mine workers work or have worked on one or more of the gold mines listed in Annexure A to this order after 12 March 1965. 1.1.2, whose claims are not among the claims which by agreement are to be determined by arbitration in the matter of Blom and others versus Anglo-American South Africa Limited. And 1.1.3, who are not named plaintiffs in the action instituted in the United Kingdom against the Anglo-American South Africa Limited under case number HQ 11X03245, number HQ 11X03246, case number HQ 12X02667, and HQ 12X05544. The silicosis class. It is declared that the following group of persons constitute a class. 2.1. Current and former underground mine workers who have contracted pulmonary tuberculosis and the dependents of deceased underground mine workers who died of pulmonary tuberculosis, but excluding silicotuberculosis, where such mine workers work or have worked for at least 2 years on one or more of the gold mines listed in Annexure A after 12 March 1965, the TB class. 3. The attorneys of record for the applicants are certified as the legal representatives of members of the classes for the further conduct of the class action as follows. 3.1. Abrams Kiewitz Incorporated, Richard Spoor Incorporated, attorneys and the Legal Resources Center are certified as the joint legal representative of the members of the silicosis class. 3.2. Abrams is certified as the legal representative of members of the pulmonary TB class. And 3.3, the fee arrangements set out in Annexure RS 13 and RS 21 to the replying affidavit of Richard Spoor are authorized in respect of the legal representative of the classes. 4. In the further conduct of these proceedings, the following applicants, whomever are surviving at the time of the class action, are granted leave to act as class representative. 4.1. The first to 52nd applicants are granted leave to act as representatives of the silicosis class, of which they are members. 4.2. The 33rd, 35th, 36th, and 53rd to 69th applicants are granted leave to act as representative of the pulmonary tuberculosis class, of which they are members. 5. It is declared that the class representatives in 4 above have the requisite standing to bring the class action and to represent members of the silicosis class and the TB class in claims for damages. 6. It is directed that the following steps shall be taken to give notice of the class action to members of the classes substantially in accordance with the notices attached as Annexure B1. 6.1. The applicant's legal representative shall forthwith publish the notice 6.1.1 as an advertisement in the newspapers listed in Annexure D hereto. The notice shall be published in each such newspaper once per week for a period of 4 weeks. 6.1.2. As a radio announcement substantially in the form of Annexure C1, broadcast on each of the radio stations listed in Annexure D and in the languages stipulated therein. Such broadcasts are to be made twice daily on alternative days for a period of 4 weeks. 6.1.3. On a prominent notice board at each of the offices of the applicant's legal representative for a period of not less than 180 days. 6.1.4. On a prominent notice board at each of the Employment Bureau of Africa in Southern Africa for a period of not less than 180 days. 6.1.5. On a prominent notice board at each Justice Center and Public Office of the Legal Aid of South Africa for a period of not less than 180 days. 6.1.6. On a prominent notice board at each regional office of the National Union of Mine Workers and the Association of Mine Workers and the Construction Union for a period of not less than 180 days. 6.1.7. By procuring Legal Aid South Africa to circulate the notice to each of its attorneys and candidate attorneys employed in providing legal aid in civil matters. 6.1.8. By delivering a copy of the notice to each advice office, paralegal office, and community-based organization with which the applicant's legal representative are familiar and which are likely, in the opinion of the applicant's legal representatives, to be approached by members of the class. And 6.1.9. On the websites of the applicant's legal representatives. 6.2. The respondents shall publish the notice 6.2.1 on a prominent notice board for the mine workers at each mine owned, operated, controlled, and or advised by the respondents for a period of not less than 180 days. And 6.2.2 on the homepage of each of the respondents' websites for a period of not less than 180 days. 7. The applicant's legal representatives are directed to file reports with the court on a quarterly basis, setting out the steps taken to publish the notice and the progress made in identifying the members of the classes. The first such report to be filed 3 months after the date of this order. 8. It is declared that any claimant who has claimed for general damages and who has died or dies prior to the finalization of his case will have such general damages transmissible to his estate, regardless of whether he has joined the class action or not. The claim of general damages in this case shall be transmissible from the date when the certification application was launched in August 2012. 9. It is ordered that members of the classes will be bound by the judgment or judgments in the first stage of the class action against the mining companies unless they give written notice to Abrams, Spoor, or LRC by 31st January 2017 that they wish to be excluded as members of any of the classes against each or any of the respondents. 10. It is ordered that 10.1, upon completion of the first stage of the class action, the members of the Silicosis class must give written notice to Abraham Spuo or LRC by a date to be determined by the court at that time. 10.1.1, that they wish to opt in and be included as members of the Silicosis class in the second stage of the class action. And 10.1.2, which respondents or respondents they seek to hold liable in the second stage of the class action. 10.2, upon conclusion of the first stage of the class action, the members of the pulmonary tuberculosis class must give written notice to Abrams by a date to be determined by the court at that time. 10.2.1, that they wish to opt in and be included as members of the TB class in the second stage of the class action. And 10.2.2, which a respondent or respondents they seek to hold liable in the second stage of the class action. 10.3, only members who give such notice timeously will have the benefit of and be bound by the judgments in the second stage of the class action as against the respondent or respondents that are found to be liable to them. 11, the reference to respondent or respondents, 11.1, in paragraph 6.2 exclude the 20th, 21st, 25th, and 26th respondents insofar as they pertain to the notice obligation and cost in respect of tuberculosis class. 11.2 in paragraph 6.2 exclude the 20th and 21st respondents insofar as they pertain to the notice obligations and costs in respect of the silicosis class. 11.3 in paragraph 13 below exclude the 20th, 21st, 29th respondents as a whole and the 25th and 26th respondents insofar as they pertain to costs of the tuberculosis class. 12. It is ordered that the respondents are jointly and severally liable for half of the mine workers' costs of publishing the notices set out in paragraph 6.1 above. 13. It is ordered that any settlement agreement reached by the parties shall only be of force and take effect if approved by this court. 14. The conditional counterclaim of the first, second, fourth to eighth, and 32nd respondents is dismissed with costs. 15. It is ordered that the respondents are jointly and severally liable for the costs of this application, which costs are to include those occasioned by the employment of 4 senior counsel and 5 junior counsel. 16. The parties are granted leave to approach this court on the same papers duly supplemented for an order varying or amplifying the provisions of this order pertaining to the notice and the costs associated with the notice in the event that this is considered necessary by any party. The entire court order, with the exception of paragraph 8 thereof, is granted by unanimous decision of this court. Paragraph 8 is granted by a majority of 2 against 1 dissension. The reason for dissent and the extent of such dissents are set out in a minority judgment of Windell J., which accompanies the written judgment for perusal of the interested parties. I hand down the judgment. The court adjourns.
Thank you.